One question I'm frequently asked has to do with emergency guardianships. Specifically, people often want to know how long it takes to be appointed as an emergency guardian for their loved one. Typically speaking, the court will only appoint an emergency guardian if that guardian can show two things. The first is that their loved one is incapacitated, and the second is that there is an immediate and irreparable threat of injury to their loved one's health. The same is true for an emergency appointment of a conservator. The petitioner needs to show that their loved one's estate or affairs are endangered and the court needs to take action immediately. If you can show the court that immediate action is needed, the court will consider your emergency request for guardianship. When the court looks at your emergency request, the court can either rule on your petition without notice or a hearing, meaning you could be appointed as a temporary guardian rather quickly, or the court will set a hearing after a short time to consider your emergency petition. The length of time between giving the court your emergency request and the hearing can differ county by county, but I'll often tell my clients to expect a couple of weeks. If, after considering your emergency request, the court decides that there is no immediate or irreparable threat of injury to your loved one, you can still file a traditional petition for guardianship. The time frame on these petitions is a bit lengthier. The court will typically set a hearing 4 to 6 weeks after the petition is filed, depending on the court's schedule. The facts of all cases are different, and so the timing of the relief you seek from the court can differ case by case. It's important to consider the facts and to present a well-thought-out argument to the court to grant the emergency guardianship before filing your request.